Hey, y'all. Y'all, shout out to all my workers. I had to get up with y'all this morning. Shout out to all my workers. Shout out to all my retirees. Shout out to all my subscribers, my viewers. Thanks for your support. Y'all come on in with me. Ain't gonna keep you all day. But it's something that I was rethinking. I was rethinking something because I may need y'all help to tell me what are they really saying about Bortlen taking that plea. So I want to ask y'all a question about Bortlen. And by the way, good morning, good evening, good afternoon, good night, y'all. So I on my way, just let the dogs out just a few minutes ago. Who let the dogs out? So like I said, workers on y'all way in when y'all get there. Check these videos up. I did a lot uploading for y'all out as well too, y'all. Some good videos, okay? It's just some things that I can say on the internet, some things that they won't let us say. So anywho, I want to get somebody in here. I'm going to talk a little bit about Bortlen taking that plea. Uh, uh, taking that plea uh deal. So y'all come on in and let's talk, like, share, and subscribe if you haven't subscribed to the channel as well. But I'm gonna go ahead on and get started because I do have people that work, and I know I have people on their way to work and people walking their dogs and just got back in the house. And so I want to understand. Maybe somebody can come in here and explain to me only about the topic that I'm talking about. Bortlen taking that plea deal, okay? What it means to him. Do he know what he's about to do? And what he's about to do is telling me that he already cooked. He gonna cook his childhood friend like like his childhood friend, best friend, cooked their childhood friend, allegedly. Okay, y'all. Like I said, I just finished walking the dog, so I'm back in the house. So we chilling. Need some more coffee, but taking that plea deal mean, and if the guys want to come in here and speak on it like that, come on in here and speak on that plea deal, okay, for me, because I never been to jail before and I never been locked up before. So him taking that plea deal, y'all make sure y'all go and check all my uploads, okay? Now, okay, 'cause, we always talk about good cops and everything, but we had some cops that did make no good decisions. So taking that plea deal, they were trying to explain to me, but I never, don't know the rules and looked it up and not sure. Taking that plea deal, that it means that uh uh just listen to the content. I just told y'all I just finished walking the dogs. Okay, taking a plea deal. I want y'all guys to tell me about this part, okay? Y'all, come on now, y'all. All right, y'all stay focused. Y'all got to help me with this. Cause it said that taking that plea deal mean pleading guilty. You don't know about Isaiah. You don't know about Melly in Bortlen case. Come on, guys. That's why I came on. So y'all can tell me. So let me finish. I ask some questions. Okay. Look at the title. It said that YNW Bortlen took that plea deal. He took it now. He already taken a plea deal. And it was mentioned to me that plea deal, you can see Minnie over there in her house right there with the dog food and Camper right here on the bed. Y'all can't see him. Uh taking that plea deal, pleading guilty, mean that he was pleading guilty. Uh and he has changed for a more lengthy sentence. And so he don't have to go to trial, y'all. He don't have to go to trial by accepting a plea. It was trying. I can't understand. He said he waived his right to confront. John, make sure you tell me about this. Hold on, let me tell y'all a little bit what I even though I looked it up, don't mean I know, you know what I mean? It said that okay, he forego his right to a trial. He waived the right to confront Melly, his witness. Wow. Did he really do that when he took that plea deal? Do he have to confront the witness? And he admitted guilt, which results in a criminal record. And it also how it works. So is that the truth, John? Do he those who up there watching y'all, I need for y'all to tell me, do that mean that Bortlen gonna have to testify? Oh man, see, y'all so lame. So anyway, it ain't nobody issue but them, but it's just we content creators. Okay. So anyway, anywho, it's nobody issue. It's just a content. We are content creators. Okay. So anybody know anybody think y'all don't have to be shy. Anyway, how it works, just in case you don't know how it works. Okay. So how it work is the prosecutor, they did offer the defense a deal. They did offer him a deal. So what they expected for Bortlen to do after making that deal is uh Judd, what you mean by who is Bortlen? Come on now, man. What's up, Les Child? Anywho, just listen. That mean that the prosecutor, I'm gonna show you him in the I got a picture up here. The prosecutor, hold on for a second. Okay, I'm sorry about that. Oh, where y'all from? Y'all might not know about this here, but where y'all from, Blessed Child? No, it's a case that oh, y'all don't know. Oh Lord. You can't be from Texas. You can't be. Cause you from Texas, you know about YNW Mellon. Come on, man. Y'all tripping. Anyway, anywho, the prosecutor had offered the defendant a deal. And the deal that they did lessened his charge. Now I read something about he's gonna do 10 years, Borland gonna do 10 years and 6 years probation. But he do have to confront the witness. And that's kind of spooky when your best friend. Now I like what Borland doing. I like what Borland doing because that's all these gangsters are doing is turning on each other. They are turning on each other anywho. So it said that you give up your constitutional right to a trial by a jury. Why they saying a trial by jury? I don't understand. Anywho, it said that the prosecutor offered the defendant a deal. That's what they did. The defendant will, with their lawyer, which he did, take a plea deal. Let me put it on now, y'all. Because y'all seen it. All right, hold on for a minute. Let me show you. Hold on, y'all. Hold on for a second. For those who just joined, I just finished walking my dog, so I just came on in the house and jump on live. Hold on. Let me see. Hold on, y'all. I'm about to show y'all. Talking about it ain't his problem. Not hold on. Okay, I'm gonna show y'all. Hold on, Blair. I know y'all heard y'all say y'all from Texas. Hold on for a second. Just hold on for a minute. I'm just gonna uh I didn't think that I would have to show y'all the video uh um because I know y'all seen this. Y'all seen this. Y'all just playing. I know y'all know about this. Hold on for a second. Let me show you. Let me show you. Hold on. Now I just didn't understand what a when they was speaking of the plea deal. Cause he all happy. The reason why I say that because Bortlen is so happy that he took the plea. And somebody asked a question in Florida. I could have asked a friend of mine, but they said in Florida. Hold on, y'all. Here you go. Hold on for a second. They say in Florida, they got to have parole. Everybody supposed to have parole. Have a parole board, but they said Florida might not have one. I said, what y'all mean by that? Hold on, y'all. Hold on, y'all. Hold on. Hold on for a second. Hold on for a second. Okay, right here. Y'all remember when they showed this? Hold on. You remember when they showed this? I didn't think I was gonna have to show it to y'all. He took a plea. He was taking a plea deal right here, Bortlen. Bortlen right there. Y'all know Bortlen. Now, Bless, you from Texas, you know. He took a plea deal. Now, okay, he took a plea deal. Uh, he was offering a plea deal from the prosecutor, meaning that, like I said earlier, that he's gonna confront Mally. You know, and I wonder, and then he ain't got to do but 10 years and 6 years probation. But why did why did they think, okay, so Cortland really told them something. Cortland had to tell the prosecutor something because, and the reason why I said that is because he made that deal. And he gonna have to follow through with that deal. And he happy that he made that deal. And that means that Melly is cooked. That means that Melly did something to them. After we found out that they were sitting at the apartment waiting on Melly in Bortlen. And then when Melly came home by herself. He didn't have Juvie with him. He didn't have Sat Chase with him. So who brought him home? Who brought him home if uh Bortlen had the car? Come on, y'all, it's common sense. So you can't save that. So I think that Bortlen thought about that because that means that you left me with our I believe Bortlen thinking like, man, you did that. You left me with these boys. You left them boys in the car with me. Then I had to drive them to the hospital. So Bortlen gonna get away. Bortlen don't got away with what he's doing. I think he already did 6 years. I'm not sure.
Swear to tell the truth, whole truth, nothing but the truth. Yes, sir. Okay. So put your hand down. Please state your full name and spell.
Let me tell y'all something. Let me tell y'all something. Just in case, hold on. Just in case y'all don't notice, that ain't that same lady right there. That's not the attorney who y'all think it is. That's not the I meant to say the prosecutor. Prosecutor is a lady got little long blonde hair who was pregnant. See, it was a black lady pregnant, and it was the other prosecutor pregnant. And so they must be the standby. She must be a standby, but that's not that lady. So who y'all think the prosecutor is? So he's talking. He's talking, but he ain't talking to them. He's talking to the other prosecutor who had that baby. And she already don't have that baby. That baby ought to be about one. That baby should be one now. She and a black attorney. Now, that's why they ain't paying no attention because he already talked to her. Now, this is Bortlen for those who from another country who don't know. That's Bortlen. He on trial right now. He on trial.
Sir, you may inquire. Sir Henry, we just want to talk about what happened in the hospital on October 26th, 2000. Do you recall driving to the hospital? If you got to speak up, answer yes or no, so this can happen. Yes. Okay. At some point, when you were brought to the hospital, were you placed into a room? When you were placed in that room, approximately how many officers were there? Um, and approximately, if you remember, how long were you in the hospital prior to the two detectives arriving? You were there for a little bit before they got there. Oh,
You know it's him. Bless. You playing. Why you
and
doing me like that?
describe to me the room that you were in.
Why you standing in the way?
Were you there by yourself with other people in the room? What was it like? Hospital room. Probably
Gosh.
um, while
Thank
you were in that hospital room at any time, were you placing handcuffs? Do you recall who placed your handcuffs? You're saying one of the officers. Are you differentiating officer versus detective? Yes. One of the officers that were standing in the room. Okay. And while you were in that room prior to giving your statement, was there always an officer in the room? At any time, were there any officers in the doorway? What were they doing? Um, at any time prior to giving your statement, did you feel as though you had the ability to get a note? What do you think, in your mind, what was your impression that would have happened to you had you tried to? Prior to, well, prior to you giving your statement to the officer, the detectives, at some point were the handcuffs taken off? Why? The urine samples. Okay. Was there a bathroom inside the hospital room? Okay, you said they walked out. Okay. And at that entire time while you're providing the urine sample, was there always an officer with you? And after you gave the urine sample, did you get brought back to the room? And at some point, there were two detectives that came. At any time during your interaction with those detectives, did you feel like you were free?
I don't know their music either.
Okay, cross-examination, go ahead.
It's his case, baby.
February
It's a case that I'm
22nd,
covering.
1983 was a pretty scary, hard day for me.
It's not the age, it's the thinking process.
Mr. Henry, you were taken into the hospital room for medical treatment, correct? Yes. You're aware that there is no urine sample in evidence.
Well, you can just chill out. Don't get upset.
It's not a check. You stated you were handcuffed. How long were you handcuffed for? So you were handcuffed for over 2 hours in that room, which you're testifying to. Same voice. Did you ever try to leave? Did you ever ask to leave? Did you ever discuss with the nurses that you wanted to leave? I'm going to show you what's being marked as states for evidence. Do you recognize this picture? Who's that a picture of? And where are you? Are you wearing handcuffs in this picture? This time it states B, the evidence is states 2.
Any objection?
No objection.
Without objection, states B for identification is now going to be an evidence that states Exhibit 2 only for the purposes of this hearing.
Mr. Henry, you agreed to ride with Detective Toyota after the crime scene? Where you said the crime occurred? Did you ride with Detective Toyota, who testified yesterday, out where you said the crime scene occurred? And you were seated in the front seat with him? There's no objections outside the scope.
Well, it is outside the scope, but over the defense's objection. Go ahead, sir. You can answer the question.
You did not ride with Detective Toyota. You were in the back seat. And at the end of your interviews with the detectives, they offered you a ride home, correct? They did not offer you a ride home? And they did not give, law enforcement did not give you a ride home? I have further questions.
All right, based on that, I agree to wet.
Well, who gave him a ride home?
Mr. Henry, this photo that you were showing of you in the hospital, do you recall what pictures being taken of you? Do you recall the officer taking photos of you? Was this taken before or after the handcuffs were taken off?
Objection, I said it doesn't call for this decision.
Hold on. Over the state's objection. Go ahead, sir. What's your answer to that question?
You said you recall some photos being taken of you. Those photos that you recall being taken, were they taken before or after the handcuffs were taken? After.
Based on that, a recross.
Yeah, John. Thank you.
Mr. Henry, I got a couple questions for you. You didn't get arrested that day, correct? How'd you get home? Someone came and picked you up from the hospital. And do you know what the time period was between that day and when you actually did get arrested?
That was October 26th. I was arrested January.
All right, state, based on my questions, do you have any additional questions?
No,
Defense, based on my questions, do you have any additional questions?
no, no.
Defense, any additional evidence, witnesses, or testimony regarding the motion to suppress?
No, John.
Okay, so it's just an argument. So, defense, it's your motion, so when you're ready, take your time. Your argument in support of your motion to suppress.
What I was asking them, John, because I ain't never, go this far like that. He took that plea deal. So he had to confront the witness. So that means that he's going to confront Melly, right?
Well, please contain that
Let's
statement.
ask him a
One,
question.
for this hearing, there's two statements. There's a longer statement that's about 40-something minutes, and then there's a very short one, which is like 2.5 minutes. You want to suppress everything. Okay, go ahead, sir.
It was on the rant, as we know. I think the state was sticking to that. But what the issue is obviously, he was not at the police station. The issue of whether he was in a situation where he should have been Mirandized. Whether the interrogation, as it were, constitutes an interrogation, whether or not it's custodial. Now, the defendant, the police had a, we heard the testimony that the car arrived at the hospital with some bodies. Mr. Henry was driving the car. Some bodies were taken into the hospital. Mr. Henry was taken to the hospital. And he told the nurse or somebody that was there that there was a drive-by shooting. He explained from where it happened. We know from what the detectives testified, other police people, personnel, that were present, and talking to Mr. Henry, then went on and walked the scene, canvassed the scene, looking for evidence of a drive-by shooting. They were unable to find evidence of the drive-by shooting, and the detectives came.
Hey, Michelle.
Referred to tape, and I just want to quote from this transcript of it. The defendant is confronted with, as he said, and the police corroborated there were at least 5 or 6 cops in the room, everybody around him. He was in a situation where he's, I'm going to call it a custodial situation when we get to that point. But anyway, the statement was, the defendant is confronted with Bertrand and Moretti. Hey, Henry. Hey, man, how you doing? What's up, man? How you guys doing? Hey, my name is Detective Bertrand. This is Detective Mark Moretti. We're here to talk to you about what happened, okay? Listen, you need to be straight up with us and tell us what happened here. My understanding, you told me off to something, but the evidence doesn't show that happened right here. That's confronting the defendant with something that's implying already saying he made a crime there, lying to the police. So we know that they're confronting him with evidence of falsehood. Should he have been Mirandized to the rest of the statement is what they're going to formulate the rest of the case. And I would submit to the court that the police had been Mirandized under that situation. They formulated, they have the crime, there's no question crimes occurred based on the crimes. The scene at the hospital was taped off. It was an active crime scene. Half the Miramar Police Department were there. 5 or 6 people were guarding him. He's in a situation where any person would feel they were not free to leave. He's in a hospital where people said there was one of the moment of the detectives corroborated. There were a bunch of police that corroborated. Was there a duty to Mirandize him? I submit to the court that it's a situation. The defense was, well, according from Hunter, Miranda warnings are required when an individual is undergoing custodial interrogation, as this court, as the Supreme Court, as this court has explained. A person is in custody if a reasonable person placed in the same situation to his or her freedom of action is curtailed to a degree of so
cases state that a hospital removal is not necessarily the equivalent of a police station, but it's not the place where the inquiry occurred. It's how the inquiry occurred and what the situation is, how the suspect proceeds. Any reasonable person, it's a reasonable man stand as to whether a person will reasonably believe they're in a situation. I'm sorry. I apologize.
D-Block, you funny. Move. Oh boy, you sound like my brother. Y'all need to stop it. Ooh, he's showing his little teeth. Okay. Okay, I see you showing your gold. You know that camera on him. Trying to be cute. You know he took that D-Block. You know he took that plea deal. Look at him showing his teeth. What is wrong with these young folks? Cause he already know what he gonna do. See, he already know what he. I, all of them tell on each other. I can't wait till the prosecutor come back. I can't wait till she come back. Mm-mm. Mm-mm. Oh, dog, why you coming here cussing? Jesus. Oh, wait. uh, let me skip it a little bit. Let me skip.
All right, Mr. Garrett, I apologize. All right, that was regarding a medical issue of women taking the call. I apologize. Go ahead. I'd like to go to Russ versus State versus Bortlen, which they relied on it so heavily in its motion because it was a hospital situation. The court stated, was correct, police are not required to give Miranda every potential suspect. Miranda warnings only
That
apply
boy
to
right there.
investigating court cases. Then it goes on to say the reasons for Miranda warnings at this stage because interrogations and certain custodial circumstances inherently coerce statements made under these circumstances are inadmissible unless the suspect is specifically warned to the precise way of oppression. And then it says for Miranda purposes, custodial question interrogation means question initiated by law enforcement officer after a person has been taken into custody in court.
Don't tell start, Kyra.
Comprise a stream of action anyway. The determination of whether a person is in custody for purposes of Miranda is how a reasonable person in the suspect's situation would perceive the circumstances.
Ooh, look how he looking at his
A
attorney.
person in custody, quoting from Hunter, a person in custody if a reasonable person, sentencing would believe that his or her action, freedom of action was curtailed to a degree associated with actual arrest. And I quoted that before. That's the situation we have here. The defendant is in a room. He is confronted by the police that they don't believe what he's telling them. So he's lying to them, they have to cooperate. And then, not Mirandai, he's surrounded by a bunch of police. Those that are down there, police are taking him to the bathroom. He's in a room where the police agree he's surrounded by police. They said there's a bunch of police. There's 4 or 5 sound people of what the defendant's saying, but they're consistent with what already testified to. How many police are here? He's in a room, it's a confined place. He's got policemen around him, and he's confronted with evidence that he's lied to the police. You need that Miranda after. It's a statement that is going to be used against him in the obstruction case or accessory case. He should have been Miranda. I think under the circumstances testified to as to how this occurred, the defendant has Miranda warning under all the cases he gives. Thank you.
Starting with Mr. Henry's testimony, he's clearly not being forthright with the court. As Detective Cox, or Officer Cox testified to, when he first got to the scene, Mr. Henry was sitting outside on a stone bench when he went over and asked him what was going on. When he is questioned in the room by the detectives, they testified he is not handcuffed. In the photograph, he is not handcuffed. Detective Toyota seems on a ride. If he was really a security risk, if he was really somebody they thought was a suspect, Detective Toyota never would have taken him on that ride, and they never would have offered him a ride home. That offer for the ride home is at the end of that recording, where they say, like, we're going to make arrangements to take you home. He was not a suspect. As the officers all, the officers all testified, they thought he was a victim. He was receiving medical treatment because, as the defendant stated, he was among the people being shot at. So when we look at whether something is custodial or not, it's the Ramirez test. It's outlined in Ross, which is the manner in which the police summoned him for questioning. He was not summoned. He brought himself to the hospital. The hospital was a crime scene. There were officers there. Crime scene was there. They were processing the vehicle. They were processing the deceased. They were processing for evidence, potentially evidence physically located on Mr. Henry as a
Oops,
victim.
sorry about that, y'all.
The fact that court heard the purpose, place, and manner of the questioning. This questioning was non-confrontational. He's not confronted with any
See, that's why he
evidence.
took that deal, because he made a deal with them.
Football casings, not sound. Confrontation is, we don't think this happened where you said it happened. And if you look at the transcript, if you read the transcript, you can see that. Because on page 9 of the transcript, they're like, look, here's a crude drawing. These guys get off the ramp here.
Hey, Evelyn.
They're trying to figure out where this happened. I think 2 of the officers go, we were trying to figure out if we even had jurisdiction over this case, depending upon where it actually occurred. There were not 5 or 6 officers in the room. That never happened. What the officers said, testified to, is that there were officers around, nearby, and there were, because this was a crime scene. There was an active shooter loose, based upon what Mr. Henry told the police, because he was a victim of a drive-by, which means somebody is driving around shooting up vehicles.
Right.
So of course, police are going to respond to that. But he's not confronted with any evidence of guilt, and even if he is, of course, considering that, as I said to in, Pitts, which is very parallel to this case at the end of my first section for issue 1, is even if they are confronted with some evidence of criminal activity, that does not necessarily transform it into a custodial interrogation. He's not confronted with any evidence of him committing a crime. It's just, did this happen where you say it is? And when we look at the entire context of the conversation, the tone, the manner, this is not an aggressive confrontation of him being a suspect. This is, tell us what happened. Where's the location? Who are the victims? What? Did anybody have a beef with you?
Sup,
Are you
Matt?
posting on social media? They're trying to figure out what happened, what is going on, the basics of the investigation. And I believe all 3 witnesses testified, we believe he was a victim at the time of that.
Thank you,
This is a
Vlad.
reasonable person's
Bless you.
standard. The fact that he
See, they don't be caring. He don't be caring. These young folks don't be caring.
And all that, yeah. Okay. If I may talk to you last word, anything else you want to but if I may, I have to disagree with the statements. I do think that the portions of the transfer where you believe that instances of detectives confronting Mr. Henry relatedly had
Uh,
not telling the true story of what happened. We see it in the second question.
me, Pablo. Me,
Henry, the second
Pablo.
question is the evidence will show that it happened there. You've lied to us. You're not telling us the truth. If you go on to page 3, you see them confront him on the bottom.
He gonna take a
Here's
plea.
the mark.
Take a plea
What
deal,
they
man.
say is that we shut down the entire area. The officers on the shoulder walking out. They just find as much as one shell casing. They go on. They end with nothing to what you said adds up. You're lying. You're not telling us the truth. There's more to this. Later on, they go on. We should expect to find evidence here. It's fragmented.
Yep.
Fragmented. Nothing. I kind of think
He
I know
gonna
what happened
snitch.
because I got information that something else happened on the east side of the city. But it sounds similar to your thing, but you didn't tell us. You be straight up with us, okay? Next question. You're doing your forensic service. So repeated examples of that telling at the beginning of the statement. What you said to us is untrue. You are lying to us. You've done an investigation. The evidence that we have doesn't match what you're saying. We're confronting you now. Lack of evidence to support your story. So clearly, you're confronting him with evidence of his guilt or involvement in some way in either the accessory after or the murder itself. And as far as arranging for a ride to go home and being in a ride along with the officers, that matters not as to what the environment was when Mr. Henry gave his statement in that hospital. He was testified to this court and found guilty of street belief. This court's going to evaluate that based on a reasonable person standard in his position. Whether or not he's in handcuffs when the statement
Hey,
occurs,
yo,
again,
man.
matters not. There are officers. He was not free to leave the hospital room. He go to the restroom. I think it's easy to understand that had he stood up and walked out of the hospital, they would have stopped him. He'd been there for some time before the statement occurred. They were collecting evidence. It was a crime scene, including evidence, GSR in his hands, taking his clothes, things of that nature. Things that a reasonable person would not understand to be happening to a crime, or someone who may be a suspect of a crime. And at the very end, Judge, whether the officers who testified in nature to be a suspect or not matters not, as the case law tells us. In Stansbury versus California, 511 U.S. 18, the police officer's subjective view of the individual is not bearing on whether or not the person believed they were in custody, whether they express it or not. It's what happened to Mr. Henry that day, and was he reasonable in believing he was not free to leave? Was his physical motion or his right to decide what to do next detailed by the action of the officers? And we would submit that it is clearly, if you evaluate just in the back of that room prior to the statement.
Well, Melly not gonna get free because he gonna take a plea
Turns out
deal.
you should never sue the driver who crashed into you after a car accident.
Melly ain't
There's
gonna
much
be
better
free.
ways to
Y'all
get
might well
paid.
hang that up
Check with
because
yourself.
his best friend about to take that plea deal. Him. He gonna tell this whole story.
Okay, listen, although normally the best practice would be for me to give you all a written order on this, I'm just going to work the bench because of the time
I
constraints.
can laugh if I want you. What you gonna do about it?
Commence the jury selection next Wednesday. So, regarding the defendant's motion to suppress statements of Cortland Henry, number one, I find witness Jordan Cox to be credible. I find witness Stephen Toyota credible. I find witness Mark Moretti credible. For the most part, I find witness Cortland Henry to be credible. Except maybe as this handcuff issue. I just don't know. There's no evidence in front to the contrary. So let me put a couple things on the record right up front. Number one, it's clearly interrogation. Okay, there's no issue about that. They're asking him questions like, did you fire a gun that day?
It's gonna be funny when
Questions that are
when he get up there and go against him.
incriminating response. It's clearly interrogation.
I'm
That's
gonna be
number one.
laughing.
Number two, certainly the best practice would be for homicide detectives to just
that on a lot of these cases. So
Thank you, hey,
they have to
Blah.
make this determination. So really, the whole ball game here is whether he's in custody. And I'm familiar with the case law that the state cited. I reviewed it again. I'm familiar with the case law the defense cited. I reviewed it again. The bottom line is, I don't think he is in custody. And I'll put the reasons why on the record. Let me also make this clear. If I had a photo in front of me, and I don't care where it was taken, if it was taken outside of the bay of the emergency room entrance, if it was taken inside the hospital, I mean, there's video cameras all over these hospitals, maybe not in the treatment rooms, but if I had any picture or any video, anything anywhere, at any point in time Mr. Henry had handcuffs on, I probably feel differently about this, but I don't. I have nothing that supports that in front of me, number one. Number two, they did in fact let him go. Number three, I think this defense is trying to give law enforcement too much credit. This is just a few hours after a double homicide occurred. And they're trying to, I guess, infer some nefarious purpose on behalf of law enforcement, that they knew Mr. Henry was a suspect, they knew Mr. Henry was going to be charged. This is the perjury trap that the defense relies on or mentions in their motion. I don't think they had any idea what had happened up to this point. It was just a few hours after a double homicide. They're just trying to figure out what's going on, to the point of putting Mr. Henry in a car and driving him to the scene that he says where this took place, because they're trying to figure it out. So they had no idea what was going on. They certainly didn't have any idea that Mr. Henry was going to end up being a defendant in this case. That seems to be corroborated by the fact that he doesn't even get arrested until more than 3 months left.
You don't see that boy right there? There he go right there.
To leave, I would feel differently about this. If he never told any witness anywhere that he didn't want to talk to them anymore, I would feel differently about this. He did no such thing. Again, based on the totality of the circumstances, I'm supposed to determine this. I listened to the questioning. I agree with the state in this part. It wasn't what I would call an intensive or aggressive questioning by the detectives based on their tone of voice and based on what they're trying to find out. They actually kind of go out of their way several times to say, listen, we don't care if you had drugs. We don't care if you were committing another crime. We don't care about anything else. We're homicide detectives. We're trying to find out what went on in the homicide. As to the defense's argument that there is a large police presence at the hospital, I would suspect that if any person in this room drove up to the hospital right now with 2 dead bodies in their car, there would be a very large police presence that would respond almost immediately to that location. So that in and of itself doesn't really sway anything in my mind. I think any reasonable person would have to expect that you drive up to the entrance of an emergency room with 2 dead people in your car who were shot, that you're going to be confronted with a rather large law enforcement presence almost immediately. So, again, based on the totality of the circumstances, where I do find that the best practice would have been to advise him of Miranda rights, and where I do find that this
What y'all don't know, this dude right here gonna turn on Melly. He's not gonna Melly ain't getting out of jail because he about to go against Melly. He took a plea charge. He took a plea deal.
I do find, based on everything that I've put on the record, that Mr. Henry was not in custody. Therefore, respectfully, the defense motion to suppress both.
Tyrone, you funny.
I'll enter a written order that reflects such. If and when we arrive at the part of trial where the state tries to introduce this, that would be over the defense objection, which I would consider to be preserved, renewed, and contemporaneously.
What's up, Adventure?
Here's how to get high when you're not 22.
Yeah, he gonna turn on. He gonna confront witness.
State unopposed motion for relief from trial order dated July 8th, 2024, and that was for the purposes of filing a motion in limine to exclude the testimony of potential witnesses Michelle Boutros and Christine Bradley. I think you all told me yesterday the defense has no objection to your unopposed motion for relief from the trial order to file the motion, number one. And number two, the motion in limine is otherwise moved because they don't intend on calling Michelle Boutros.
Right. Dog
Is
win.
that correct?
I believe that's correct.
Is that correct?
Okay, the way it stands, I don't believe they would.
All right, so,
Should that happen?
okay, well, as far as the motion for relief, just to file your motion, that's granted.
and I'll enter a written order as to that. Regarding the state's motion in limine, I'll defer on that, and I'll enter a written order. And if no one calls them as witnesses, it's not an issue. And if someone's going to call them as a witness or wants to, I'll address it and give you a ruling on that. And if that requires me to send a jury out and even take a proffer from either one of these witnesses, it doesn't seem like it's going to be too long a time. But I'll take a
Victor, you
proffer from
funny.
them if I need to outside of the presence of the jury before I make a ruling. Although I can tell you,
You right,
general
Norman.
policies, but as a general rule,
No nothing.
credibility of witnesses is always an issue. So if we're talking about the credibility of a witness in the case, a witness that one side or the other side needs the jury to believe to have the jury believe their version of the facts of the case, then I would probably be hard pressed to say that I would prevent any witness testimony in front of the jury in that regard. But I'll enter all three of those orders today. Let's go back to this one. On top is granted. The reasons stated on the record, and then the motion limited underneath is deferred. The reasons stated on the record.
The motion hasn't actually been filed yet. Just has to
Oh, you're gonna file it. I'll consider it.
tonight, but we'll
Do they have a copy? They were a copy.
Yes, there.
All right, so I'll consider the state's motion in limine based on my ruling granting the relief from the trial order filed today, which is September the 5th, and I will defer ruling on it based on what I already put on the record. State, is there anything else that you need me to do for you regarding Mr. Henry today?
Not later.
Defense, is there anything else that you need me to do regarding Mr. Henry today? Not today. Thank you. So, Mr. Henry's going to keep a couple things. Number one, next Tuesday, September the 9th at 1:30 p.m., we'll call that a trial status. So the record is clear on this. If there's going to be some sort of resolution, it has to be Tuesday afternoon. I can't take it Wednesday morning because I'm going to have the jurors here. There's simply too much human resources involved with this. And if Mr. Henry's case does resolve, and again to repeat what I said yesterday, it doesn't matter to me whether it does or it doesn't. I have a couple other murder trials that are in line.
Yeah, he guilty. But
Yeah, just sign it. We'll give you a blank order. Just fill it out. It says I need him here Tuesday, September the 9th at 1:30 p.m. 1:30 p.m. Mr. Henry, Tuesday would be the last day you're dressed like that. We go forward with the trial on Wednesday. I need you in your trial clothes. Okay, dress for trial on Wednesday. We're gonna have jurors here Wednesday. And then he has, besides the September 9th date at 1:30, he keeps his trial dates for September the 10th at 9 o'clock. I don't need an order for one.
okay, for those who don't know, I first of all I want to thank y'all. Thank y'all for I just walked the dog not too long ago, but shout out, like to early in the morning people because I used to work at this time early in the morning. Bortlen took a plea deal. He took a plea, okay? He's gonna confront. He got 10 years doing I think he do 6. He do 6 on probation. And he's gonna have to confront his witness. So that's what they was telling him about his sentence. Somebody asked me about the sentence. That's what's gonna happen. So what do y'all think? Somebody said free Melly, but how we gonna free Melly and how y'all gonna free Melly and his witness? His partner about to go against him, y'all. His partner about to go against him. So there ain't no free no Melly because y'all got to remember this. Melly came home by herself. Melly didn't come home with Bortlen. Melly didn't come home with Juvie. Melly didn't come home with Sat Chase. Melly came home with Melly Right. Melly is cooked. So those who talking about free Melly, you're going to be saying free Melly forever because he ain't getting out. Even though they're going to have a trial, he's not getting out because this boy right here about to tell everything. He already done told Christina everything. See, the prosecutor not in that courtroom, but she working behind the scenes. She and that other lady, remember they was pregnant at the same time. She the one handle, what his name? What's that other rapper name? Yeah. Every man for themselves. And that's what all them gonna do. They gonna turn on each other. But he better, I know he gonna tell, I know it's freaked him out. I know it's freaked Bortlen, like Bortlen look at softer than Melody to me. And you know he don't want to do no time in jail. You know he don't want to do no time. But anyway, when that trial come in, y'all, I'll be him. but we will always have the song murder on my. I don't like that song. I don't like that song. I don't like them song right there they sing. I just want to make sure justice is served for I wish I can find so y'all can see him taking that plea. He was just grinning, showing out here gold in his mouth. I can't find it right now. But oh, there he go right there showing out his gold. Cause he took that plea deal. Let me let y'all see him showing the gold in the mouth.
This isn't just any
I
chat.
didn't too much.
Click up chat.
I don't.
You can
I don't know why. Vaughn. I like the Vaughn better than I like Melly. I don't know why.
But this is it
See him?
today.
This when he took that
Understanding
plea.
all that, you've had enough time to talk to your lawyers about all that. That's what you want to do. So, sir,
Hold on, y'all. Let me put it on the beginning. This is when he took that plea.
The story
So
feels like a
yeah.
complete mess, doesn't it? Trying to
Boy,
determine
y'all, I be
what's really
tripping. I
being
be
held.
tripping.
You know there's a plot
Them
hole
don't be
chapter
laugh.
14.
Y'all got to get to
You're
know
too
me.
deep.
Them don't be laugh. They be tripping.
record, this is on the top of my page 5, state Henry, 191871 CF10A, and
Hey,
2020
baby.
10643 CF10A. I've got Ms. Collins, Mr. Griffiths present for the state. I've got Mr. Henry,
Dog,
present
we.
for Mr. Henry, who likewise is present. So I had said this afternoon, put the deadline as to whether or not Mr. Henry wanted to accept the state's offer or not. We were set to go to jury. So Mr. Haddad or Mr. Nascimento will go forward and take your plea this afternoon.
What time is it?
And state the same terms that you discussed previously.
Blast, why you worrying about the time? You didn't retire? See, I'm a retired person, so I don't have to worry about the time no more.
19 case as to the 2 counts of accessory after the fact, as well as to all 4 counts. The 23 case, these are going to be adjudications. 10 years Florida State Prison, followed by that's 6 years probation. 6 years probation. All counts are currently all sentences for
Okay.
another.
The judge over there talking, the judge just gave him 10 years and do 6 years on probation. Oh, I don't worry about the time no more because I'm retired, so I can go to sleep and wake up when I want to. Ah.
It looks like there's no restitution in the 23 case. In the 19 case, I'm reserving restitution and ordering it payable. That's going to be to Terry Bagley as well as Ashley Phillips.
No more slack.
Spoken to them and they don't anticipate there being any restitution just because it's on.
Well, I'll give you 120 days to tell me the amount.
Yes, Your Honor. They are present as well.
You go to work. He said you have to go work in an hour.
So, as of today, they said there is none.
All right, state
You ain't but 35. You the same age as my daughter.
Also went to giving his proffer, Your Honor.
part, is that part of the negotiated resolution?
It is.
Tell me how that works.
So I'm only 35. I like I'm 35.
Sure. Come on. Madam Clerk, please.
Man, you know what, Sly? I don't worry about no time no more, man. All them years of working, no Lord, have mercy, Jesus. Okay, congratulations.
Mr. Henry, I'm going to put you under oath, and I'm going to ask you some questions.
Uh-uh.
If I ask you something you don't understand, please let me know. I'll try to ask you a better question, okay? As loud as you can so the court reporter can get down all the answers, okay? Raise your right hand.
Yeah, it's they not talking loud, so it's not my computer. It's them. They not talking loud for some reason. I didn't work. I wouldn't worry about it either. I did all my life.
Swear to tell the truth, whole truth, nothing but the truth. Then put your hand down. Please state your full name. How old are you? How far did you go in school? Can you read and understand the English language? Are you presently under the influence of any
Yeah,
drugs,
bless.
medication, or alcohol? Have you ever been treated for a mental illness? Are they giving you any medication in the jail right now? How are you feeling this afternoon? Your head is clear? You understand what's going on this afternoon? You understand you're resolving 2 pending felony cases this afternoon? Mr. Haddad or Mr. Nascimento, have you seen or heard Mr. Henry say or do anything which would call into question
Yep,
whether
Jeff.
what's going on? All right, so Mr. Henry, it's 2 cases, sir. I'm going to go one at a time. In case number 19-1871 CF10A, this is before the agreement you made with the state, before the deal you made with the state. You were charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital offenses. The maximum and mandatory penalty is life in Florida State Prison. Counts 3 and 4 are accessory after the fact of murder in the first degree. Those are each first degree felonies. The maximum penalty is 30 years in Florida State Prison. In case number 23-10643 CF10A, you're charged in count 1, tampering with a witness in a capital felony. That is punishable by life in Florida State Prison. Count 2, directing the activities of a criminal gang. That's a first degree felony. Again, punishable up to life in Florida State Prison. Count 5 is conspiracy to commit tampering. Again, as it relates to a first degree murder charge, that is punishable by a maximum penalty of life in Florida State Prison. And count 7, unlawful use of a two-way communication device as charged. That's a second degree felony. The maximum penalty is 15 years in Florida State Prison. So, sir, again, before the agreement you made with the state, before the deal you made with the state, your maximum exposure here was life in Florida State Prison, followed by 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 75 years in Florida State Prison. Sir, do you understand all the pending charges and the maximum possible penalties involved? And it's my understanding that you want to resolve both cases today. Is that correct? And that resolution is an agreement you've reached with the state, the terms of which are as follows. Number 1, in the 19 case, you're going to plead no contest to both counts of accessory after the fact. In the 23 case, you're going to plead no contest to all 4 counts as charged. In exchange for that, the state is going to null process, that is, drop the 2 first degree murder cases. All right, I'm going to adjudicate you guilty. Yes, sir.
He about to get out.
So he's only going to plead to the tampering with a witness in a capital felony, conspiracy to commit tampering, and unlawful use of the two-way communication device.
Just the tampering and unlawful use.
Just count 1 and count 7. State, you're going to null process count 2 and count 5.
Correct.
As it relates only to Mr. Henry. Okay. So, Mr. Henry, what it's going to be is 2 counts of accessory after the fact, tampering with a witness in a capital felony, and unlawful use of a two-way communication device. In exchange for that, I'm going to adjudicate you guilty on the 2 accessory counts as well as the tampering count. I'm going to sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation. In the unlawful use of a two-way communication device, that's a second degree felony. The maximum exposure. It's a second as charged, I believe. It's a third, except as it relates to a capital case. But I'm happy to look it up. So what did you want the negotiated sentence to be for that?
He gave the prosecutor some information, y'all.
Okay. All right, so sir, as to that count, it's going to be adjudication of 5 years in Florida State Prison. So the 2 accessory counts as well as the tampering count, those come with 6 years of reporting probation after the Department of Corrections sentence. I'll give you credit for all the time that you've served in both cases. All of those counts will run concurrently. All those sentences will run concurrently. All counts in all cases, that is at the same time with each other. I'm going to have to impose mandatory court costs. I'm going to order restitution.
Yeah, dog, we big time.
And payable to Ashley Phillips and reservists to the amount. I'm going to give the state 120 days to tell me the amount of that restitution. If they fail to do so within 120 days, there will be no restitution. If they come back with an amount and the attorneys agree on the amount, I will impose that as another condition of your sentence to pay back that restitution. If they come back with an amount and the attorneys do not agree on the amount, I will conduct a restitution hearing. Sir, lastly, and I want to make it very clear on the record that it's unrelated to this negotiated change of plea, I guess at some point after the fact, the state wants to take a proffer from you or have a discussion with you ask you some questions about whatever that may be. What I want you to understand, sir,
They
and I
scary.
guess that's part of this negotiated resolution, but your answers to any of those questions, whatever they might be, have no bearing on me and have no bearing on this negotiated resolution. In other words, the deal you negotiated is the deal you negotiated, and that's the ball. You understand all that, sir? Have you had enough time to talk to your lawyers about all that? They've
He
answered all
act
your questions.
confused.
You're sure that that's what you want to do? Because I want to emphasize, Mr. Henry, and I'm going to do this again at the end of my plea colloquy. Whether you resolve the case by way of a negotiated plea or an open plea to me, or you resolve the case by way of a trial, it doesn't matter to me at all. But due to the resources that have been devoted to this case, I have 250 jurors summoned for jury duty starting tomorrow. So I want to be very thorough with you here this afternoon, because if you wake up tomorrow or the next day and
There
decide
you
to
go,
change your
dog.
mind and you want to resolve this case, both cases, by way of a jury trial, that's not going to happen. All right? If you want to have a trial, the trial starts tomorrow. If you want to accept the deal, you can accept the deal today. But there's not going to be any buyer's remorse, in other words, because I've given you plenty of time to think about this, talk to your lawyers about it, talk to your family about it. I talked to you about it last week. Kind of looks like your lawyers probably did something or other to get a better disposition for you as of this afternoon. But this is it today. So understanding all that, you've had enough time to talk to your lawyers about all that. That's what you want to do. So, sir,
Nah, he just gonna be in the house. Nah, they ain't gonna give him no protection. But they about to let him out though.
Was sexually exploited, abused.
Ooh, Lord, honey, what you talking about? Ooh. Commercial. You about to get out. They telling you.
threatened you or coerced you into entering these pleas. If I accept your pleas, there will not be a trial in either one of these cases. Do you understand that?
You know
If
what?
I accept
Hold
your
up.
pleas, there's a whole bunch of constitutional rights.
Lieutenant, I heard that. That's why when I first came on, I was asking them questions. They said they don't have parole in Florida. That's crazy. They don't have parole in Florida. That's what I heard. So he did the best thing. But it's another question I want to ask them, Lieutenant, that he's gonna do he have to confront his witness? Do he have to confront the witness, Melly's? That's the question I'm trying to get. Do he have to confront Melly, the witness, his friend?
You are giving up. I want to make sure you understand all of those rights. You have the right to maintain your plea of not guilty and have a trial in each case. You have the right to present defenses, to file motions and other pleadings in support of your defense. You have the right to remain silent. You have the right to have the state prove you guilty beyond a reasonable doubt.
Oh, okay.
You have the right to confront and cross-examine the witness.
So you mean to tell me that a man who was involved in a double murder about to walk the street doing 6 years probation? Are you serious? But he did exchange a deal with the prosecutor. He did tell the prosecutor something for real.
Any decisions that I may have made up to this point, or any rulings I might make.
Yeah, he told them prosecutor something.
But understanding by entering this negotiation,
He said, "Welcome to America."
all of those rights. The matter is going to be resolved today, right now, this afternoon. Is that what you want to do? Are you satisfied with your lawyers? Have you had enough time to speak with them? Have they answered all your questions?
Yeah,
Are
he
you
got to do them
satisfied
10
with
years
all
for
the
him.
work that they have done for you? Sir, I've got 2 identical plea forms here entitled Plea of Guilty or No Contest to Criminal Charges in Circuit Court. Each one has your name on the top, your initials on the left-hand side, front and back, and your signature on the back. Did you go over both of these forms? Any questions about what's on either of these forms? And is
Yeah.
that your signature on the back of each form? Sir, there's a few things that I need to tell everyone that I take a plea from. They may or may not apply to you. If you are not a citizen of the United States, these pleas will result in your deportation. Do you understand that? Under the provisions of the Jimmy Rice Act, if the offenses to which you are pleading are sexually violent or sexually motivated offenses, or if you've been previously
You can't go out of town, buddy.
then these pleas will subject you to an involuntary civil commitment as a sexually violent predator upon completion of your sentences. Do you understand that? If these are drug offenses, the Department of Motor Vehicles will revoke your driver's license for a period
You
of 1
can't do
year.
nothing. He can't do nothing. He don't even have a life.
Sir, paragraph 11 of each form that you signed reads as follows. I acknowledge that my attorney and I have reviewed any discovery disclosed by the state. My attorney and I are unaware of any physical
You think
evidence
so?
DNA may exonerate me. In other words, sir, if there's any physical evidence in the case that we could test for DNA, that DNA evidence would not tell me that you were not one of the people in that vehicle.
Yeah, I never heard of that. They don't have parole. That shocked me. Look at Melly family right there.
That DNA evidence would tell me that you were one of the two people that
That's
was inside this
crazy.
vehicle when these crimes occurred. Sir, do you agree with that statement? State, do you agree with that statement? Defense, do you agree with that statement? Mr. Henry, understanding everything that I have talked to you about up to this point, do you still want to go ahead and resolve both cases today, right
Surely he
now?
does that.
Defense,
He
is he
won't be
stipulating to a factual
dead.
basis?
I don't think so either, dog. I was nervous about that.
And if he's entitled to a PSI defense, are you going to waive that as to
Really?
state? Is there anything else that you need me to do before I take this?
I don't. I don't like that. I don't like that. Because, but he made that plea though. He made a plea.
So,
He
Mr.
made
Henry,
that plea.
again, two cases. We're going to do one at a time.
There go Melly people.
Case number 19,
Look.
1871 CF10A. As to count 3, accessory after the fact to murder in the first degree. And as to count 4, accessory after the fact.
There go his mama.
How are you going to plead, sir? Guilty, not guilty, or no contest? In case number 23, 10643 CF10A. As to count 1, tampering with a witness in a capital felony. And count 7, unlawful use of a two-way communication device.
That's what I heard too, Lieutenant.
Not guilty or no contest. I will accept your no contest pleas as to each.
That's the first time I ever heard of no parole.
Based upon my review.
First time when I looked it up.
As well as your stipulation in court here today, I'm going to further find that you have freely, voluntarily, and intelligently waived your rights, that you have knowingly entered each plea with the advice of competent counsel, who you told me that you are satisfied with, that you understand the nature.
Look at him playing with his gold in his mouth.
Accordingly, and pursuant to the negotiated agreement, I will sentence you as follows. In case number 1871 CF10A, as to count 3 and count 4, I will adjudicate you guilty, sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation. I will impose mandatory court costs. Pursuant to 943.325, I will need a set of your prints and DNA. Pursuant to 938.27, I will impose a cost of prosecution.
Y'all, I don't think they put him in a good situation. I don't think he's in a good situation. Because I'm going back to one of y'all, what one of y'all say, he ain't going to be out. And when he get out, he ain't going to be out long. Especially when they're going to keep Melly. You said with state, that lets parole that man get off.
$100. Sir,
So
I'm also
he
ordering restitution.
yeah, he had 10 years and he ain't got to do but six year probation. He put himself in that situation. Nah, what I'm saying, Lieutenant, what I'm saying is, why he taking that plea? When he get out, he already done did some of his time. He done did some of his time. So, it's a whole other country. Sly said,
I'm going to give the state 120 days to tell me the amount of the restitution. If they fail to do so within 120 days, there will be no restitution.
he ain't gonna
If they
do
come
right.
back with an amount, the attorneys agree on the amount, I will impose that as another condition of your sentence to pay back. If they come back with an amount and the attorneys do not agree on the amount, I will conduct a restitution hearing. That will conclude that matter. In case number 23-10643 CF10A, as to
Even
count
if
1 and
you
count
own
7, I will
at
adjudicate
10
you
in
guilty.
Florida
Count 7
State
is a
Prison,
sentence of 5 years in Florida
you
State Prison.
is
Count 1 is a
like,
sentence of 10 years in Florida
which
State
is
Prison,
gonna
followed by
give
6
him
years of reporting
more
probation.
years.
I will impose mandatory
Oh, I
court
got
costs
you
in that
now.
case
It's a
as well.
trick.
I will not impose the cost of prosecution in that case as I just did so in the previous case. Pursuant to
He will get the
943.325,
death
I will need
sentence
another
here.
set of your prints and DNA.
And,
All of these, there is no restitution.
what you say, Troy?
All of these sentences,
So
Both cases will run concurrently at
so
the same time with each other.
I think they already done cut his hair off his head. He ain't gonna fight nobody. They gonna have to fight him. He ain't gonna fight nobody.
I will give you credit for all the time that you have served. State
He about to get out.
191871 CFNA, your announcement as to counts 1 and 2. And in case number 23-10643 CF10A, state your announcement as to count 2 and count 5.
I heard they don't cut their hair off.
I think that concludes all the matters. State, is there anything else that you need me to do regarding Mr.
He's not in Nebraska. You need this. What he said, expresses later. He better not drop the Oh, help me, Jesus. He said, better not drop it. So y'all a mess. He doesn't have to. You get extra time for even self-defense. What? This a trip. This a trick. God, see, I can't go to jail. I can't go to prison. I'm sorry, y'all. I have to give it to y'all. Whoever do it. I wonder how much time he already done.
We've already spoken with BSI. I think we're just in an order.
I mean, I was going to make it available.
Wow.
Okay. So they're in charge. Anything else from the defense on behalf of Mr. Henderson?
I wonder how much time he already
Mr. Henderson,
did.
I'm not quite sure how your lawyers managed to do this, but I wish you good luck, sir.
Oh.
We'll have a probation officer here tomorrow. He'll be on my docket tomorrow morning.
Look, I see what they talking about him. Yeah, boy. I have a good time with him.
So I will sign all the
Check
paperwork.
another inmate in Nebraska. You still want to commit crime in 2025. Ooh, wee. Chad. I'm going to tell you something. I don't think it's safe for him to be, I really don't think it's safe for him to be on the street. I really don't. Because Nelly, I just looked at his family. I just looked at his family over there. They didn't look too happy. He let me see what y'all say. Y'all a mess. Said, God, let me see, read that. Let me see. Y'all still want to commit. I know they still want to commit crime in 2025. I want to know who shot them boys. Nebraska don't play. Okay. He gonna start working in the field unless he got to a facility. They supposed to move him to a facility. A live-in facility with everybody else. They move him to a facility, I think. What's the name of that facility they move him to, Lieutenant? He is of someone from the other side. He won't watch the movie life. Don't cross the. I'm gonna tell you something. Y'all don't know what he told that he going to work now because I think they said that he in some kind of facility now. But God, what am I about to tell you about him? About Bortlen. Bortlen told the prosecutor something. He told the prosecutor. He made a plea deal with the prosecutor. So it's something he told the prosecutor. No clue. I'm from okay, PA. Where's PA at? He gave some information. He showed did try to the state. Do you hear how happy that Judge Sam? That judge sounds so happy. They sound like, and then he's smiling over there. He's smiling uh at Melly people. I don't trust him. I don't trust him. He Yeah, he gave them some good information. Yeah, I don't like this part. But y'all, thank you for joining. Y'all, thank you for joining. I thought about coming live when I walked the dog a little bit. I ain't go too far. But I appreciate y'all. Y'all like, share, and subscribe. And thank you for watching with me, okay? And thanks for giving me too. All right, y'all. I'm gone, okay?